Yes, that level of consideration
most especially
for
Bella
him will continue.
and the courageous survivors who join us here today. It
Chief
is an
Justice.
honor to be with you on this historic day.
Oh, the senator from Washington.
Mr. Chief Justice, I send a question to the desk for the House managers.
Thank you.
As the President reflected, we're here to commemorate the 20th anniversary of the Trafficking Victims Protection Act. As the President's made clear, from his heart, we have a President who knows human trafficking is not only an unconscionable evil, but an
Senator
epidemic
Murray
in
asks
the
the
world
House
today,
managers.
and the United States of
Yesterday,
America will
when asked
confront it
about
as
why
never
the House
before.
did not amend or reissue subpoenas after it passed its resolution authorizing
Mr. President, you said in your
inquiry,
proclamation
the House managers
marking
touched
this
upon
past
the House
month that
having
human
the sole
trafficking is an
power of
affront to
impeachment as
humanity, and you've
specified by
taken
Article
decisive
1
action
of the
to
Constitution.
bring human traffickers to
Could you
justice, their
further
victims to
elaborate
safety,
as to why that
and to help
authority
survivors walk
controls,
the difficult
despite
road
any arguments
to
brought
recovery?
forth by members of the
Like
defense
no
team
president before
contesting
you,
the validity
you've
of
made it a
those
priority to
subpoenas?
target transnational criminal organizations that have victimized thousands of innocent people on both sides of our borders.
Mr. Chief Justice and senators, that's a good question. The answer is that these were validly issued subpoenas under the House rules. The White House argument to the contrary is wrong, and it would have profound negative implications for how Congress and our democracy function. On January 9th, 2019, the House adopted its rules like we do every Congress, and these rules gave the committee the power to issue subpoenas. They're not ambiguous rules, and here is the relevant portion of Rule 11 on slide 55. The House's standing rules give each committee subpoena power for the purpose of carrying out any of its functions and duties as it considers necessary. This investigation began on September 9th, before the Speaker's announcement on September 24th that it would become part of the impeachment inquiry umbrella. The President doesn't dispute that the subpoenas issued by these committees were fully within their respective jurisdiction. The argument is that somehow, by declaring that this investigation also falls under an inquiry to consider articles of impeachment, which gives Congress actually greater authority, that somehow it nullifies the traditional oversight authority, and this just doesn't make any sense. Now, the President counters that we have to take a full vote on impeachment first because that's what's been done in the past. In the Nixon inquiry, however, the Judiciary Committee needed a House resolution to delegate subpoena power, and that's different than the committee standing rules today. Precedent actually compels the opposite conclusion. Several federal judges have been investigated, impeached, and convicted in the Senate without the House having ever taken an official vote to authorize the inquiry, and a federal court recently confirmed there was no need for a formal vote of the full House to commence impeachment proceedings. But even assuming a House vote was necessary, there was a vote. The text of House Resolution 660 declared that the 6 investigative committees of the House were directed to continue their ongoing investigations as part of the existing House of Representatives inquiry and whether there was sufficient grounds for the House of Representatives to exercise its constitutional power to impeach. And the committee report, which accompanies the resolution, specifically described the subpoenas that had been issued by the investigating committees and said, quote, "All subpoenas to the executive branch remain in full force." So why didn't the House committee just reissue these subpoenas after the resolution? The short answer is they didn't need to. The subpoenas were already fully authorized. In any event, even after the resolution passed, the committees issued subpoenas to Mick Mulvaney, Robert Blair, 4 other witnesses, and the President continued to block those subpoenas. The argument about a full House vote really is just an excuse about President Trump's obstruction. The President refused to comply with the House subpoenas before the House vote and after the House vote. The only logical explanation is the one that President Trump gave us all along. He was determined to fight all the subpoenas because in President Trump's view, according to what he said, he can do whatever he wants. Now, that's not what the constitutional republic entrusted to us by the founders had in mind. This argument doesn't just apply to impeachment. It would apply to ordinary oversight investigations. And it doesn't just apply to the House. It would also apply to the Senate. By sanctioning the President's blanket obstruction, The Senate would be curtailing its own subpoena power in the future, as well as the House's. And the oversight obligation that we have, as we now know it, would be permanently altered. I yield back.
Thank you, Ms. Manager.
Mr. Chief Justice,
Senator from Kentucky.
I have a question to present to the desk for the House Manager Schiff and for the President's Counsel.
The presiding officer declines to read the question as submitted.
Mr. Chief Justice.
The senator from Wisconsin.
Mr. Chief Justice, I send a question to the desk.
Thank you. The question from Senator Baldwin is addressed to the House managers. Given that the White House counsel could not answer Senator Romney's question that asked for the exact date the President first ordered the hold on security assistance to Ukraine, what witness or witnesses could answer Senator Romney's question?
Thank you, Chief Justice. Thank you, Senator, for the question. You're right. They were not able to directly answer that question. And we believe that there is a tremendous amount of material out there in the form of emails, text messages, conversation, and witness testimony that could shed additional light on that, including an email from last summer between Mr. Bolton, Mr. Blair, where we know from witness testimony this issue was discussed. What we do know is from multiple witnesses, Ukrainian officials knew that President Trump had placed a hold on security assistance soon after it was ordered in July of 2019. So we know that not only did U.S. officials know about it and OMB communicate about it, but the Ukrainians knew about it as well. We know from former Deputy Foreign Minister of Ukraine, Elena Zirkle, she stated publicly, in fact, that the Ukrainian officials knew about it and had found out about it in July. We also know from the testimony of Laura Cooper that her staff received 2 emails from the State Department on July 25th, revealing that the Ukrainian embassy was, quote, asking about security assistance, end quote. And that, quote, the Hill knows about the FMF situation to an extent, and so does the Ukrainian embassy, end quote. And that was on July 25th, the same day as President Trump's call with President Zelensky. What we also know is that career diplomat Catherine Croft stated that, quote, she was very surprised at the effectiveness of my Ukrainian counterparts' diplomatic tradecraft, as in to say they found out very early on or much earlier than I expected them to, end quote. We also know that Lieutenant Colonel Alexander Vidman testified that by mid-August he was getting questions from Ukrainians about the status of security assistance. So there is a lot of evidence surrounding it. The administration continues to obstruct wholly our efforts to get the emails and correspondence that we have asked for. That obviously can be remedied by this body with the appropriate subpoenas, namely a subpoena to Ambassador Bolton to testify, and a subpoena to the State Department and Department of State and Department of Defense and others to actually provide that material. Last thing I'd like to say is last evening, Counsel for the President was asked the question about why did the hold for Ukraine differ from holds in the Northern Triangle and other holds like Afghanistan. He provided an explanation that I'm still trying to wrap my brain around because he seems to be the only person in the administration that actually has an explanation. And as far as I could tell, the explanation was somewhere along the lines of one was public and trying to put public pressure on the countries in question, and one was not, was a private conversation and a private effort to put pressure. If that were true, then of course there would be plenty of evidence, plenty of emails, text messages, and other correspondence within the entire interagency process that we know is robust that would illustrate that to be the case. But they have failed to provide any evidence to corroborate that. And let me finish with this. I happen to know that a lot of people in this chamber, a lot of people in the chamber on the other side of the Capitol, including me, have often described much consternation about red tape and bureaucracy and layers of government that run too slow. And I sometimes share that concern, right? That sometimes it takes a long time. There are memos for everything, emails for everything. There's paper trails for everything in this town. I think that is true with respect to this issue. And it is time that we actually see that information so we can get to the bottom of what actually happened. This body could get that information.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Pennsylvania.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Sass, McSally, Crapo, Thune, Young, Ernst, and Braun.
The question from Senator Toomey and other senators is for counsel for the President. Given that the election of the President is one of the most significant political acts in which we as citizens engage in our democratic system, how much weight should the Senate give to the fact that removing the President from office and disqualifying him from ever holding future federal office would undo that democratic decision and kick the President off the ballot in this year's election?
Members of the Senate, one of the concerns that we've raised throughout this process over the last several months, and going back to the time when the House was dealing with this in their various committees, is we're in an election year. There are some in this room that are days away from the Iowa caucuses taking place. So we're discussing the possible impeachment and removal of the President of the United States, not only during election season, in the heart of the election season. And I think that this does a disservice to the American people. Again, we think the basis upon which this is moved forward is irregular, to say the least. But I do think it complicates the matter for the American people, that we are literally at the dawn of a new season of elections. I mean, we're at that season now. And yet, we're talking about impeaching a president. And I want to tie this into the urgency that was so prevalent in December with my colleagues, the managers. It was so urgent to move this forward that they had to do it by mid-December, before Christmas, because national security was at stake. And then they waited 33 days to bring it here. And now they're asking you to do all the investigation, although they say they, proved their case, but still need more to prove it. Of course, we believe, and I want to be clear here, that their entire process was corrupt from the beginning, and they're just putting it on this body. But to do it while the American people are selecting candidates for nomination to be the head of their party, to run as President of the United States. Some of you in this very room. And to talk about the removal of a President of the United States, I think that's all part and parcel of the same pattern and practice of irregularities that have taken place with this impeachment proceeding since the beginning. The Speaker allowed the articles to linger. It was such a nationally urgent matter that they could linger for a month. So we think that this points to the exact problem what's taking place here, and that is, as my colleague, Mr. Cipollone, has said, this is really taking the vote away from the American people. Thank you, Mr. Chief Justice.
Thank you, counsel. The senator from Montana.
Mr. Chief Justice, I send a question to the desk for the House managers.
Thank you. Senator Tester asks the House managers. Yesterday, Mr. Dershowitz stated, quote, if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment, end quote. Do you believe there is any limit to the type or scope of quid pro quo a sitting president could engage in with a foreign entity as long as the intent of the sitting president is to get reelected in what he or she believes is in the public's best interest?
Chief Justice, Senator, there is no limiting principle to the argument that we heard last night from the President's team. That is, if there's a quid pro quo that the President believes will help him get reelected, and he believes his reelection is in the national interest, then it doesn't matter how corrupt that quid pro quo is. It's astonishing that on the floor of this body someone would make that argument. Now, it didn't begin that way in the beginning of the President's defense, but what we have seen over the last couple days is a descent into constitutional madness, because that way madness lies. If we are to accept the premise that a president essentially can do whatever he wants, engage in whatever quid pro quo he wants, I will give you this if you will give me that to help me get elected. I will give you military dollars if you will give me help in my reelection, if you will give me illicit foreign interference in our election. Now, the only reason you make that argument is because you know your client is guilty and dead to rights. That is an argument made of desperation. Now, what's so striking to me is almost half a century ago, we had a president who said, well, when the president does it, that means it is not illegal. That, of course, was Richard Nixon. Watergate is now 40 to 50 years behind us. Have we learned nothing in the last half century? Have we learned nothing at all? It seems like we're back to where we were. If the president says it, it's not illegal. Or Donald Trump's version, under Article 2, I can do whatever I want. Or Professor Dershowitz's point, if the president believes it helps his reelection, it is therefore in the national interest. He can do whatever he wants. In fact, much as we thought that we progressed post-Watergate and we enacted Watergate reforms and we tried to insulate the Justice Department from interference by the presidency, we tried to put an end to the political abuses of that department, as much as we thought we enacted campaign finance reforms, we are right back to where we were half a century ago, and I would argue we may be in a worse place, because this time, that argument may succeed. That argument, if the president says it can't be illegal, failed. And Richard Nixon was forced to resign. But that argument may succeed here. Of lawlessness. I would hope that every American understands that, and every American understands it's true for Democratic presidents and Republican ones. I would hope that we would understand it. I would hope that this trial would be one conducive of the truth. The senator asked what witnesses could shed light on when the president ordered the hold and why. Well, we know Mick Mulvaney would. That instruction came from OMB. You remember the testimony of Ambassador Taylor, the shock that went through the National Security Council and the shock he experienced in that video conference when it was first announced. And the instruction was, this comes through the President's Chief of Staff, OMB, but it's a direct order from the President. Well, Mick Mulvaney knows when that order went into place, and he knows why that order went into place, and he made that statement publicly, which he now wishes to recant. I'm sure he got an earful from the President after he did. But apparently it doesn't matter. None of that matters. Because if the President believes it's his interest, it's okay. Now, there was an argument also, well, what if it was a credible reason? Of course, there's no evidence that this was a credible reason to investigate the President's rival, but let's say it was a credible reason. Does that make it right? What president is not going to think he has a credible reason to investigate his opponent? What president is going to think he doesn't have a credible reason or wouldn't be able to articulate one or come up with some fig leaf? They compounded the dangerous argument that they made that no quid pro quo is too corrupt if you think it'll help your reelection. They compounded it by saying, and if what you want is targeting your rival, it's even more legitimate. That way, madness lies.
Justice,
The senator from North Dakota.
I send a question to the desk on behalf of myself and Senator Young.
Thank you. The question from Senator Kramer and Young is for the counsel for the President. Manager Schiff regularly states that if the President is innocent, he would agree to all of the witnesses and documents that the managers want. Is the President the first innocent defendant not to waive his rights? If the President is innocent, he would agree to all of the witnesses and documents that the managers want. Is the President the first innocent defendant?
Mr. Chief Justice, Senator, thank you for that question. Because the answer is obviously no, the President is not the first innocent defendant who decided not to waive his rights. And I think it is striking and shocking that one of the arguments that has been repeatedly deployed by the House managers throughout these proceedings, we heard Manager Nadler say, only the guilty hide evidence. Only the guilty don't respond to subpoenas. And Manager Manager Schiff say that this is not the way innocent people act. Well, of course, that's contrary to the very spirit of our American justice system, where people have rights, and asserting those rights cannot be interpreted as an indication of guilt. That is expressly forbidden by the laws and by the Constitution. And the Supreme Court explained in Bordenkircher versus Hayes, a case that's cited in our trial memorandum, that the very idea of punishing someone, which is what the House managers are attempting to do here with their obstruction of Congress charge, to say that if the President insists on the constitutional prerogatives of his office, if the President insists that, like virtually every president, at least since Nixon, and some going beyond further back to that, he's going to assert the immunity of his senior advisors to compelled congressional testimony, if he's going to assert those rights grounded in the separation of powers and essential for protecting constitutionally based executive branch confidentiality interests, we're going to call that obstruction of Congress and impeach him. And it's this fundamental theme running throughout both their obstruction charge and their arguments generally here, that if the President stands on his constitutional rights, if he tries to protect the institutional prerogatives of his office, which he is duty-bound to do for future occupants of that office, that's somehow an indication of guilt and shows that he ought to be impeached. And that's fundamentally antithetical to the American system of justice and to our principles of due process, to our principles of acknowledging that rights can be defended, that rights exist to be defended, and asserting those rights cannot be treated either as something punishable or as evidence of guilt. And there would be a long line of past precedents presidents, as Professor Dershowitz pointed out, there are a lot of presidents who have been accused of abuse of power. There'd also be a long line of presidents who could have been impeached for quote-unquote obstruction of Congress if every time a president insisted upon the prerogatives of the office of the presidency and insisted on defending the separation of powers, that could be treated as something impeachable and as evidence of guilt. President Obama himself refused to turn over a lot of documents to the House. In the Fast and Furious investigation, his attorney general was held in contempt. But no one thought that that was an impeachable offense. So the concept of saying that when the president asserts constitutionally grounded prerogatives of his office, that is evidence of guilt, is a completely bogus assertion. It's contrary to all the principles of our American justice system and to fundamental principles of fairness, and it ought to be rejected by this body. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Alabama.
Thank you, Mr. Chief Justice. I send a question to the desk.
Thank you.
It's contrary to all the principles of our American justice system and to fundamental principles of fairness, and it ought to be rejected by this body. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Alabama.
Thank you, Mr. Chief Justice.
Senator Jones's question is for the House managers. Aside from the House's constitutional impeachment authority, please identify specifically which provision or provisions, if any, in the House rules or a House resolution authorize the subpoenas issued by the House committees prior to the passage of House Resolution 660. In addition, please list the subpoenas that were issued after House Resolution 660.
Senator, we will compile the list. We don't have it accessible at the moment in answer to a question. Oh, we do have it? We do have it. Let me just, if I could, specifically the subpoenas that went out after the passage of the House resolution were a subpoena to John Eisenberg, a subpoena to Brian McCormick, Robert Blair, Michael Ellis, Preston Wells Griffith, and Mick Mulvaney. But let me underscore something that my colleague Manager Lofgren had to say. And let me break this down, if I can, in very practical terms. What is the practical import of what counsel for the president would argue? And it is this. Let's say that a Democrat is elected in November. And let's say that any one of you that chair a committee in the Senate determine that you think that the next president has engaged in something questionable, maybe even some wrongdoing, and you begin an investigation. And I would imagine that your Senate rules, like our House rules, and it's House Rule 10, Senator, that has the specific language authorizing the issuance of subpoenas as a part of our normal oversight responsibility. That power didn't exist at the time of Watergate, so they had to have a separate resolution. But that House rule passed each session empowers us to issue subpoenas as committee chairs as part of our oversight jurisdiction. So there you are, Democratic president, you're a chair. You start to do oversight, you issue subpoenas. You start to learn more, and what you learn becomes more and more concerning. And you issue more subpoenas. And the administration, in an effort to cover up their misconduct, says, we're not going to comply with any of your subpoenas. We're going to fight all subpoenas. And they come up with one bad faith excuse after another as to why they don't have to comply. And as you investigate further, and you're able to overcome the wall of obstruction, then you begin an impeachment inquiry, and that leads to the passage of yet another resolution. They would argue to you that all the work you did before you determined that it merited potential impeachment must be thrown out, that they were perfectly empowered to obstruct you in your oversight responsibility, that you must begin with your conclusion, that you must begin with the conclusion that you are prepared to impeach the president before you issue a single subpoena. Otherwise, they can say whatever you did before you got to that place should be thrown out. Now, we did not have the Justice Department do the initial investigation here. Why? Because Bill Barr turned it down. The same Attorney General mentioned in that July 25th call said there's nothing to see here. So there was no DOJ investigation. There was no special counsel investigation. It wasn't as if someone like Ken Starr handed us a package and said, here's the evidence. Now you can take up a resolution, an impeachment resolution, because we have done the investigative work. No, we had to do that work ourselves. And they would have you believe that any subpoena you issue as a part of your oversight responsibility, that down the road reveals evidence that leads you to embark on an impeachment inquiry, must be disregarded. That cannot and is not the law. It would render the oversight function meaningless. Court after court that has looked at the Congress's power to issue subpoenas have all reached the same conclusion, and that is, if you have the power to legislate, you have the power to oversee. Here we have a violation of the Impoundment Control Act. That is, Congress passes military spending, the president doesn't spend it, he gives no reason, he keeps it a secret. We're investigating that. That can't be more squarely within the oversight power of Congress, to find out why aid we appropriated was not going out the door. They would say, you can't look into that unless you're prepared to impeach the president and announce it firsthand. That's the import of that argument. It would cripple your oversight capacity, and without your oversight capacity, your legislative capacity is crippled. That's the real-world import of this legal window dressing. They would strip you of your ability to do meaningful oversight. And particularly here, where we're talking about misconduct of an impeachable kind and character, it would mean that a president can obstruct their own investigation. And if you need any evidence of their bad faith, of which is abundant, the shifting and springing rationalizations and explanations, when we had Corey Lewandowski in the Intelligence Committee, they said that under instructions to the White House, he wouldn't answer questions because they might claim executive privilege. Now, this was someone who never worked for the executive. They made the claim they might use executive privilege. I'm sorry, is my time up?
Time has expired.
Okay, thank you.
The senator from Texas.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Hawley and Graham.
Thank you. The question from Senator Cruz, along with Senators Hawley and Graham, is for both sides, the counsel for the President and the House managers. Yesterday, Manager Demings refused to answer whether Joe Biden sought any legal advice concerning his conflict of interest on Burisma, the corrupt Ukrainian company that was paying his son Hunter $1 million per year. USA Today reported that when asked about it, Vice President Biden said, excuse me, quote, he hadn't spoken to his son Hunter Biden about his overseas business, end quote. That account was contradicted by Hunter Biden, who told the New Yorker that he told his father about Burisma and, quote, Dad said, I hope you know what you're doing, and I said, I do. Why do Joe and Hunter Biden's stories conflict? Did the House ask either one that question? The White House counsel goes first.
You heard our answer. I'm sorry, Chief Justice, Senators. Senators, you heard our answer regarding that yesterday, but it is very interesting that he said he never spoke to his son about overseas dealings. His son said different things. Joe Biden was the point man for Ukraine, investigating, at the time, Ukrainians were a corrupt company, Burisma, and Zlochevsky, its owner, an oligarch who by all media accounts we've discussed was extremely corrupt. Hunter Biden is paid $83,000 a month to sit on that board with no experience in energy, no experience in the Ukraine, doesn't speak the language, and we clearly know that he had a very fancy job description, and he did none of those things. He attended 1 or 2 board meetings, one in Monaco, and then he went on a fishing trip with Joe Biden's family in Norway. The entire time, Joe Biden knows that this oligarch is corrupt. Everyone knows that. There are news reports everywhere. No one will dispute that. In fact, it raised eyebrows worldwide. But the vice president, by his account, never once asked his son to leave the board. We wouldn't be sitting here if he did. He never asked his son to leave the board. Instead, he started investigating the prosecutor who was going after Burisma and this corrupt oligarch who they say was corrupt even by oligarch standards, who had fled the country, living in Monaco. He does not ask him to leave the board. He does the opposite. In 2015, what does he do? We know by reports he has close contact with President Poroshenko. He travels to Ukraine twice. He links it to he links the aid to the firing. Same thing in 2016 at a White House meeting. Links the aid to the firing of the prosecutor. Calls him 4 times in the 8 days up to leading to the prosecutor. The prosecutor investigating Hunter Biden, yet he never says that. All cases closed. Days before Biden leaves office, he jokes to Poroshenko that he may have to call him every couple weeks to check in. Hunter Biden stays on that board for 3 years. 3 years. Then we hear the video of Joe Biden bragging about firing the prosecutor, linking it to aid. Then we have the 6-minute phone call.
Mr. Chief Justice. Oh, there's the
Oh,
other
I'm
half.
sorry.
I'm
The House managers have 2.5 minutes.
Mr. Chief Justice, and to our senators. Senators, thank you so much for that question. I know you have asked about a conversation between a father and his son. And what I can tell you, probably like just about everybody in this chamber, there are probably some conversations that I can't repeat to you about my conversations with my son. So I don't know the answer to your question, Senator, what that exact conversation was. But what I can tell you is this. If we are serious about why we are here, and I have no reason to doubt that we are, if we are serious about seeking the truth, because the truth matters, not just for those who have paid the price in our history to form a more perfect union and protect our democracy, but it's important for our future. And in this case, if we're serious about that, then I can tell you this, that we are serious then about hearing from fact witnesses. Looking at the Bidens, no matter how many times we called their name, we have no evidence to point to the fact that either Biden has anything at all to tell us about the president shaking down a foreign power to help him cheat in the next election, the precious election, trying to steal each individual in this country's vote. I don't believe either Biden has any information about that, but let me tell you who I think does. Maybe we should call Ambassador Bolton. If we're serious about the truth, maybe we should call him because we have a good idea about what he might say. Or what about Mr. Mulvaney, who had day-to-day contact with the principal in our investigation, the President of the United States? That's not good enough? Well, what about, the question was asked about when did we know? Or when did the President first put the hold on? Well, we do have reports that say on June 19th of 2019, Mr. Blair personally instructed the director of OMB to hold up security assistance from Ukraine over a month before the infamous July 25th call. So,
thank you, Mrs. Manager
thank you,
Demings.
Mr. Chief Justice.
Mr. Chief Justice,
Oh,
I send a question.
the senator from Nevada.
I send a question to the desk.
Thank you. The question from Senator Rosen is addressed to the House managers. Over the course of your arguments, you have tried to make a case that the President put his personal interests over those of the nation, risking our national security in the process. What precedent do you believe the President's actions set for future presidents?
Mr. Chief Justice, Senator, thank you for that question. It's one that I've wanted to answer for some time now. You've heard me speak before about some of my personal experience and service to the country, and one thing that experience has taught me is that we are strong not just because of the service and the sacrifice of our men and women in uniform, which is extreme and pure in all of its sense, and something that I think everybody in this chamber actually appreciates and respects. But we are also strong because we have friends. We are strong because America doesn't go it alone. You know, when I was in Iraq and Afghanistan, I worked frequently with Afghan Army partners, Iraqi Army partners, and others, not because it was important, but because it was essential, that we couldn't accomplish the mission without it. But if those partners feel like our policies, what we say publicly, don't matter, if they feel like we are not a reliable and predictable partner, if they feel like the American handshake isn't worth anything, then they will not stand by us. They will not stand by us. And for over 70 years, since the end of World War II, the partnerships, the alliances that we have built, that we have strived to create, that has ushered in an unprecedented period of peace and prosperity throughout the world, will start to fray, because the American handshake will not matter. Ukraine has started to learn that. Our 68,000 troops throughout Europe deserve better, because every day they get up and they do their job, the job that we have asked them to do. And they rely on our consistency, our predictability. They rely on the interest being in the national interest, not the whims and the personal interest of the president, whether that be President Trump or any other president. It will continue to call into question our broader alliances. And it will send a message that the American handshake doesn't matter. We have a slide that shows the evolution of some of the different arguments that we've seen on the other side that I think is important to see.
Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press. Let's see if that happens.
Campaign this time around, if foreigners, if Russia, if China, if someone else offers you information on an opponent, should they accept it or should they call the FBI?
I think maybe you do both. I think you might want to listen. There's nothing wrong with listening. If somebody called from a country, Norway, we have information on your opponent. Oh, I think I'd want to hear it.
You want that kind of interference in our elections?
It's not an interference. They have information. I think I'd take it.
Let's move to the third excerpt that I mentioned related to Vice President Biden. And it says, the other thing, there's a lot of talk about Biden's son. This is President Trump speaking.
that Biden stopped the prosecution, and a lot of people want to find out about that. So whatever you can do with the Attorney General would be great. Biden went around bragging that he stopped the prosecution, so if you can look into it, it sounds horrible.
Well, I would think that if they were honest about it, they'd start a major investigation into the Bidens. It's a very simple answer. If we feel there's corruption, like I feel there was in the 2016 campaign, there was tremendous corruption against me. If we feel there's corruption, we have a right to go to a foreign country. And by the way, likewise, China should start an investigation into the Bidens, because what happened in China is just about as bad as what happened with Ukraine.
The American people deserve to know what happened. The American people deserve to know when they go to bed tonight that there's a president that has their interests in mind, that will put the national security of the country above his own political self-interest. The American people deserve answers, and yes, it is still a good time to call Ambassador Bolton to testify.
Thank you, Mr. Manager. The senator from Ohio.
Mr. Chief Justice, I send a question to the desk on behalf of myself, Senators Toomey, Cornyn, Crapo, Ernst, and Moran.
Thank you. The question from Senator Portman and the other senators is for the counsel for the president. I have been surprised to hear the House managers repeatedly invoke constitutional law professor Jonathan Turley to support their position, including playing a part of a video of him. Isn't it true that Professor Turley opposed this impeachment in the House and has also said that abuse of power is exceedingly difficult to prove alone without any accompanying criminal allegation? Abuse of power has never been the sole basis for a presidential impeachment and was not proven in this case.
Mr. Chief Justice, Senators, thank you for that question. And that is exactly correct. Professor Turley was very critical of the entire process in the House and of the charges that the House Democrats were considering here, both the abuse of power charge and the obstruction charge. And he explained that this was a rushed process that had not adequately pursued an investigation, that, as the senators point out in the question, abuse of power is an exceedingly difficult theory to use to impeach a president, and it has never been used without alleging violations of the law. And I think that in the discussions we've had over the past week and a half, we've pointed, pointed that out multiple times. Every presidential impeachment in our history, including even the Nixon impeachment proceedings, which didn't actually lead to an impeachment, have used charges that include specific violations of the law and the criminal law. Andrew Johnson was charged mostly in counts that involved violation of the Tenure of Office Act, which the Congress had specifically made punishable by fine and imprisonment, and even wrote into the statute that violation would constitute either a high crime or a high misdemeanor, but one of those terms to make it clear that it was going to be used to trigger an impeachment. In the proceedings, in the Nixon impeachment inquiry, each of the articles of impeachment there, except for the obstruction of Congress charge, was sort of treated separately on the obstruction theory, included specific violations of law. There were specific violations alleged in the second article of impeachment, which is often sort of referred to loosely as the abuse of power article. It wasn't actually titled abuse of power. It didn't charge abuse of power. The specifications there were violations of law, violating the constitutional rights of citizens, violating the laws governing executive branch agencies, unlawful electronic surveillance using the CIA and others, specific violations of law. And clearly in the Clinton impeachment, President Clinton was impeached for perjury and obstruction of justice. Those are crimes. And while Professor Turley does not take the view that a crime is necessarily required. He pointed out here that there was not nearly a sufficient basis and not nearly a sufficient record compiled in the House of Representatives to justify an abuse of power charge. He also was very critical of the obstruction of Congress theory, and he pointed out that it would be an abuse of power by Congress under these circumstances, where Congress has simply demanded information, gotten a refusal from the executive branch based on constitutionally based prerogatives of the executive, a refusal to provide that information, then to simply go straight to impeachment without going through the accommodations process, without considering contempt, without going to the courts. That was Professor Turley's view, how incrementally the House of Representatives would have to proceed if they were going to try to reach, ultimately, some theory of obstruction of Congress. So to cite Professor Turley, it is true that in his academic writing and in his testimony, he did not adopt the view that you must have a crime and only a crime as the charge for an article of impeachment. He still thought that neither of the articles of impeachment here could be justified or were sufficient or could be used to impeach the president, both the abuse of power article and the obstruction article. So taking snippets out of what he said really does an injustice to the totality of his testimony, because the totality of his testimony was entirely against what the House ended up doing here. Thank you.
Thank you, counsel. The senator from Ohio.
Mr. Chief Justice, on behalf of Senator Wyden and myself, I send a question to the desk for the House managers.
Thank you. Senator Brown and Wyden ask the following question for the House managers. During yesterday's proceedings, the President's counsel failed to give an adequate response to a question related to whether acceptance of information provided by a foreign country to a political campaign or candidate would constitute a violation of the law, and whether offers of such information should be reported to the FBI. FBI Director Christopher Wray, who was appointed by President Trump, has said, quote, "If any public official or member of any campaign is contacted by any nation state or anybody acting on behalf of a nation state about influencing or interfering with our election, then that is something that the FBI would want to know about," end quote. And we'd like to make sure people tell us information promptly so that we can take the appropriate steps to protect the American people, end quote. If President Trump remains in office, what signal does that send to other countries intent on interfering with our elections in the future, and what might we expect from those countries and the President?
Mr. Chief Justice, distinguished members of the Senate, thank you for that question. To take the last part first, it would send a terrible message to autocrats and dictators and enemies of democracy and the free world for the president and his team to essentially put out there for all to consume that it's acceptable in the United States to solicit foreign interference in our free and fair elections or accept political dirt, simply to try to cheat in the next election. I was certainly shocked by the comments from the President's Deputy White House Counsel yesterday, right here on the floor, when he said, "I think the idea that any information that happens to come from overseas is necessarily campaign interference is a mistake." No, it's wrong. It's wrong in the United States of America. He also added information that is credible that potentially shows wrongdoing by someone that happens to be running for office if its credible information is relevant for the voters to know to be able to decide on who is the best candidate. This is not a banana republic. It's the Democratic Republic of the United States of America. It's wrong. Now, the single most important lesson that we learned from 2016 was that nobody should seek or welcome foreign interference in our elections. But now we have this president and his council essentially saying it's okay. It is not okay. It strikes at the very heart of what the framers of the Constitution were concerned about: abuse of power, betrayal by the president of his oath of office, corrupting the integrity of our democracy and our free and fair elections by entangling oneself with foreign powers. That's at the heart of what the framers of the Constitution were concerned about. Don't just trust me. We have several folks who have made this observation. The FBI director, the Trump FBI director, said that the FBI would want to know about any attempt at foreign election interference. And the chair of the Federal Elections Commission also issued a statement reiterating the view of U.S. law enforcement. She said in part, "Let me make something 100% clear to the American people and anyone running for office. It is illegal for any person to solicit, accept, or receive anything of value from a foreign national in connection with a U.S. election. This is not a novel concept. Election intervention from foreign governments has been considered unacceptable since the beginning of our nation. It is wrong, it is corrupt, it is lawless, it's an abuse of power, it's impeachable, and it should lead to the removal of President Donald John Trump."
Thank you, Mr. Manager.
Mr. Chief Justice,
Senator from Missouri.
I send to the desk a question on my own behalf and on behalf of Senator Lee.
Thank you. The question from Senators Hawley and Lee is for counsel for the President. United States federal courts have held, most prominently in the Blagojevich case, that it is not unlawful for a public official to condition his official acts on official acts performed by another public officer. Is there any application to the allegations against President Trump?
Mr. Chief Justice, Senators, thank you for that question. I think an important threshold point to make here is that we're not even in the realm of exchanging official acts because there's been no proof of a quid pro quo here. We're not in the realm of a situation where there's one official act being traded for another. I think that we've gone through the evidence that makes it quite clear that both with respect to a meeting with the President, a bilateral meeting, and with respect to the temporary pause on the security assistance, the evidence just doesn't stack up to show that President Trump linked either of those. Both took place, the meeting and the release of the aid, without Ukrainians doing anything, announcing or beginning any investigations. There's nothing in the transcript linking them as a quid pro quo. The Ukrainians didn't even know that there had been a temporary pause on the aid. And I could go on with the list of points on that. I think if there were any application, hypothetically, it would come in the realm of the fact that in foreign policy, there are situations where there can be situations where one government wants some action from another and wants that action from another in a way that will condition other policies of one country. You can say, we would like you, and this happens, for example, with the Northern Triangle countries. We want you to do more to stop the flow of illegal immigration. We're going to be conditioning some of our policies towards you unless and until you start doing a better job stopping the flow of illegal immigration, because it's a real problem on our southern border. That happens all the time. And when there's something legitimate to look into, there could be a situation where the United States would say, you've got to do better on corruption, you've got to do better on these specific areas of corruption, or we're not going to be able to keep having the same relationship with you. One example like that, I believe we've pointed out that aid was held up to Afghanistan. President Trump held up aid to Afghanistan specifically because of concerns about corruption. And in situations like that, there'd be nothing wrong whatsoever with conditioning one policy approach on a foreign country, modifying their policy to be more in line, to attune more directly to U.S. interests. That's part of what foreign policy is all about. And that could arise in the situation of even investigations. And I think it's interesting to point out that in May of 2018, 3 Democratic senators sent a letter to the then prosecutor in Ukraine suggesting that we've heard some things that you might not be cooperating with the Mueller investigation. And there is sort of an implicit indication behind the letter that there's not going to be as much support for Ukraine. This is something that's important. You've got to be helping with that election. And there's nothing wrong with encouraging the prosecutor general to assist with something that's important to the United States. That's part of foreign policy. It happens all the time. So to the extent that that case, the Blagojevich case is relevant, I think it is in the general concept that were there some linkage between we want your country to pursue these policies, it's going to affect our policies towards you, that's entirely legitimate. That's not something that is a violation of any law or is improper. But again, I come back to the point that here, there is no proof of that linkage. There is no proof that there was any sort of, as we've come to call it, quid pro quo in this case. Thank you.
Thank you, counsel. The senator from Washington.
Mr. Chief Justice, I send a question to the desk.
Thank you. Senator Cantwell's question is for the House managers. In his opening remarks, Chairman Schiff said the Ukraine scheme was expansive and involved many people. Is there any evidence that acting White House Chief of Staff Mick Mulvaney, Secretary of State Pompeo, Attorney General Barr, or anyone on the outside were involved in this scheme to withhold military aid or obstruction of Congress?
Mr. Chief Justice and Senator, thank you so much for that question. If we remember Ambassador Sondland's testimony where he said everyone was in the loop, but we don't just have to take his word for it. During his hearing, Mr. Sondland discussed a July 19th email he sent to the President's top aides, including Secretary Mike Pompeo, Acting Chief of Staff Mick Mulvaney, Mr. Mulvaney's Senior Advisor Robert Blair, Secretary Rick Perry, and Brian McCormick, Secretary Perry's Chief of Staff. And we should at least start with, if we're serious about getting to the truth, issuing a subpoena for State Department emails. If you'll pay attention to the slide, in the email, Sondland stated, quote, "I talked to Zelensky just now. He is prepared to receive POTUS's call. We'll assure him that he intends to run a fully transparent investigation and will turn over every stone. He would greatly appreciate a call prior to Sunday so that he can put out some media about a friendly and productive call, no details." Mr. Mulvaney in the email acknowledges receipt and responds shortly, "I asked the NSC to set up the call for tomorrow, 6 days before President Trump, now infamous July 25th call, in which he told President Zelensky to conduct investigations into the Bidens and the 2016 election. Mr. Sondland sent an email to the president's top aides updating them on the status of the scheme. Again, quote, everyone was in the loop. On August 11th, Ambassador Sondland emailed Mr. Breckball to ask him to brief Secretary Pompeo on a statement he was negotiating with President Zelensky with the aim of, quote, making the boss happy, the boss being the president, enough to authorize the investigation. Ambassador Sondland wrote to Mr. Breckball, and I quote, Kurt and I negotiated a statement from Z, Mr. Zelensky, to be delivered for our review in a day or two. The contents will hopefully make the boss happy enough to authorize an invitation. And he's talking about the invitation for a White House Oval Office meeting, which we know was much more critical and important than a sideline meeting at the UN. Yet, further evidence, and I quote, everyone was in the loop. Attorney General Barr reportedly responded at some point. There was a New York Times article that was done, and Attorney General Barr responded to that article by stating that he was aware of DOJ investigations into some countries, and that he was concerned President Trump was giving world leaders the impression he had undue influence over what would ordinarily be independent investigations. He cited conversations the president had with leaders of Turkey and China, further demonstrating that there was concern about the president abusing the power of his office for personal political reasons. Again, it proves that everybody was in the loop, and we should want to subpoena and review those emails involving the State Department and others.
Thank you, Mrs. Manager.
Mr. Chief Justice,
Senator from South Dakota.
I sent a question to the desk on behalf of myself and Senators Moran, Daines, Ernst, Scott of Florida, and Crapo.
Thank you. Senator Thune and the other senators ask the counsel for the president. On March 6, 2019, Speaker Nancy Pelosi said, quote, impeachment is so divisive to the country that unless there's something so compelling and overwhelming and bipartisan, I don't think we should go down that path because it divides the country, end quote. Alexander Hamilton also warned in Federalist 65 against the, quote, persecution of an intemperate or designing majority in the House of Representatives with respect to impeachment. In evaluating the case against the President, should the Senate take into account the partisan nature of the impeachment proceedings in the House?
Thank you, Mr. Chief Justice, members of the Senate. Absolutely, you should take that into account. That's dispositive. That should end it. Based on the statements that we heard the last time from our friends on the Democratic side, that's a reason why you shouldn't have an impeachment. Speaker Pelosi was right when she said that. Unfortunately, she didn't follow her own advice. We've never been in a situation where we have the impeachment of a president in an election year with the goal of removing the president from the ballot. As I've said before, that is the most massive election interference we've ever witnessed. It's domestic election interference. It's political election interference, and it's wrong. They don't talk about the horrible consequences to our country of doing that. But they would be terrible. They would tear us apart for generations, and the American people wouldn't accept it.
The horrible consequences.
Let me address in that context the importance of the vote for their inquiry, which also had bipartisan opposition. Now, they said, well, we were fine when Speaker Pelosi announced it. We didn't need a vote. The subpoenas were authorized. Then why did they have a vote? They had a vote because they understood they had a big problem that they needed to fix.
We didn't need a vote.
But what's more important about the vote than the procedural issue? The important thing about the vote is that if you're going to start an impeachment investigation, particularly in an election year, there needs to be political accountability to the American people. You can't just go have a press conference. If you're going to say that the votes of the American people need to be disallowed, that all of the ballots need to be torn up, then at the very least, you need to be accountable to your home district for that decision. And now they are. And now they are. And if the American people decide, if they're allowed to vote, if the American people decide that they don't like what's happened here, that they don't like the constitutional violations that have happened, that they don't like the attack on a successful president for purely partisan political purposes, then they can do something about it, and they can throw them out. That's why a vote's important. But we should never even consider removing the name of a president from the ballot on a purely partisan basis in an election year. Important? I'll say it's important for that reason alone, and for the interest of uniting our country. It must be rejected. Thank you, Mr. Chief Justice.
Thank you, counsel.
For that reason alone,
Mr. Chief Justice.
for the interest of uniting our country.
Senator from Rhode Island.
Mr. Chief Justice, I send a question to the desk on behalf of Senator
you, Counsel.
Duckworth, Senator Harris, and myself, for the House managers and for the President's Council.
Thank you. Senator from Rhode Island.
Mr. Chief Justice, I send a question to the desk on behalf of Senator Duckworth, Senator Harris, and myself, for the House managers and for the President's Council.
Thank you. Senator from Rhode Island.
Mr. Chief Justice, I send a question to the desk on behalf of Senator Duckworth, Senator Harris, and myself.
The question from Senator Reid and the other senators is for both parties, beginning with the House managers. It has been reported that President Trump does not pay Rudy Giuliani, his personal attorney, for his services. Can you explain who has paid for Rudy Giuliani's legal fees, international travel, and other expenses in his capacity as President Trump's attorney and representative? Explain who has paid for Rudy Giuliani's legal fees, international travel, and other expenses in his capacity as President Trump's attorney and representative. Explain who has paid for Rudy Giuliani's legal fees, international travel, and other expenses in his.
The short answer to the question is, I don't know who's paying Rudy Giuliani's fees. And if he is not being paid by the president to conduct this domestic political errand for which he has devoted so much time, if other clients are paying and subsidizing his work in that respect, it raises profound questions, questions that we can't answer at this point. But there are some answers that we do know. As he has acknowledged, he's not there doing foreign policy. So when counsel for the president says this is a policy dispute, you can't impeach a president over policy, what Rudy Giuliani was engaged in by his own admission has nothing to do with policy. It has nothing to do with policy. And let me mention one other thing about this scheme that Giuliani was orchestrating and the consequence of the argument that they would make, that its quid pro quos are just fine. Let's say Rudy Giuliani does another errand for the president, this time an errand in China. And he says to the Chinese, we will give you a favorable deal with respect to Chinese farmers as opposed to American farmers. We will betray the American farmer in the trade deal, but here's what we want. The quid pro quo is, we want you to do an investigation of the Bidens. You know the one the president's been calling for. They would say that's okay. They would say that's a quid pro quo to help his reelection. He can betray the American farmer. That's okay. That's their argument. Where does that argument lead us? That's exactly the kind of domestic, corrupt political errand that Rudy Giuliani was doing gratis, without payment, at least not payment apparently from the president. So who's paying the freight for it? Well, I don't know who's directly paying the freight for it, but I can tell you the whole country is paying the freight for it. Because there are leaders around the world who are watching this and they're saying the American presidency is open for business. This president wants our help, and if we help him, he will be grateful. He will be grateful. Is that the kind of message we want to send to the rest of the world? That's the result of normalizing lawlessness of the kind that Rudy Giuliani was engaged in.
Thank you. I'm sorry, your time has expired. Counsel?
Came out of the manager's mouth. Open for business. I'll tell you who was open for business. You know who was open for business? When the Vice President of the United States, who was charged by the then President of the United States with developing policies to avoid and assist in removing corruption from Ukraine, and his son was on the board of a company that was under investigation for Ukraine, and you're concerned about what Rudy Giuliani, the president's lawyer, was doing when he was over trying to determine what was going on in Ukraine? And by the way, it's a little bit interesting to me, and my colleague, the Deputy White House Counsel, referred to this. It's a little bit ironic to me that you're going to be questioning conversations with foreign governments about investigations when three members of the Senate, Senator Menendez, Senator Leahy, and Senator Durbin, sent a letter that read something quickly like this. They wrote the letter to the Prosecutor General of Ukraine. They said they're advocates, talking about the congressman, they're strong advocates for robust and close relationship with Ukraine, and we believe that our cooperation should extend to such legal matters, regardless of politics, and their concern was ongoing investigations and whether the Mueller team was getting appropriate responses from Ukraine regarding investigations of what? The President of the United States. And you're asking about whether foreign investigations are appropriate? I think it answers itself. Thank you, Mr. Chief Justice.
Thank you, counsel.
Mr. Chief Justice.
The senator from Oklahoma.
Mr. Chief Justice, I sent a question to the desk on behalf of myself, Senator Ernst, and Senator Crapo.
Thank you. The question from Senator Langford and the other senators is for the counsel for the president. House managers have described any delay in military aid and State Department funds to Ukraine in 2019 as a cause to believe there was a secret scheme or quid pro quo by the president. In 2019, 86% of the DoD funds were obligated to Ukraine in September, but in 2018, 67% of the funds were obligated in September, and in 2017, 73% of the funds were obligated in September. In the State Department, the funds were obligated September 30 in 2019, but they were obligated September 28 in 2018. Each year, the vast majority of the funds were obligated in the final month or days of the fiscal year. Was there, was there a national security risk to Ukraine or the United States from the funds going out at the end of September in the two previous years? Did it weaken our relationship with Ukraine because the vast majority of our aid was released in September each of the last 3 years?
Mr. Chief Justice, Senators, thank you for that question. And the short, straightforward answer is there was no jeopardy to the national security interest of the United States from the timing of the release of this money. As the question indicated, the vast bulk of funds in each of the prior two fiscal years were also obligated in September. So the fact that the funds were released here on September 11th and obligated by the end of the fiscal year was consistent with the timing in past years. There was, and it's also the case that at the end of every fiscal year, there is some funding in this Ukrainian military assistance that doesn't actually make it out the door, that isn't obligated by the end of the fiscal year. We've heard the House managers point to the fact that Congress had to put something in the continuing resolution, a special provision, to get $35 million of the aid extended so it could be used in the next fiscal year. My understanding is that every fiscal year there's some amount of money. It's not always that same amount, but there's some amount of money that has to be done for every year because it doesn't get out the door by the end of the year. Now, it's not just from the raw data that we can see that the funds went out roughly the same timing towards the end of the year, that therefore it doesn't suggest any great risk to Ukraine or risk to the national security of the United States. We know that from testimony as well. Ambassador Volker testified that the brief pause on the aid was not significant. And Undersecretary of State for Political Affairs David Hale explained that this is future assistance. And I mentioned this the other day. It's not like this money is being spent month by month to supply current needs in the Ukraine. It's 5-year money. Once it is obligated, it can go to U.S. firms who are providing material to the Ukrainians, and it doesn't get spent down finally and material shipped to Ukraine for a long time. So a delay of 48 or 55 days, depending on how you count it, and the money being released before the end of the fiscal year ends up having no real effect. It's not current money that's supplying immediate needs, despite what we've heard about the idea that on the front lines in the Donbass, Ukrainian soldiers are being put at risk. That's just not accurate. And we know that also from Oles Sevchuk, the Ukrainian Deputy Minister of Defense, who gave an interview to the New York Times and explained that the hold came and went so quickly that he didn't even notice any change. And remember, the Ukrainians didn't even know. President Zelensky and his advisors, Yermak and others, have made it abundantly clear. There was another interview just the other day with Daniluk, who, I might get his title wrong, I think he was the foreign minister at the time, but there was an interview just the other day that was published, and he explained again that they didn't know the aid had been held up until the Politico article on August 28th. And then he said there was a panic in Kiev because they were just trying to figure out what to do. Well, within 2 weeks, it had been released. And so we've also heard the idea that, well, it was just the fact of the delay that gave the Russians a signal and it gave the Ukrainians a signal, and that was what the damage to national security was. But the whole point is the leaders of the government in Ukraine didn't know. It wasn't made public. So they weren't being given a signal by that, and the Russians weren't being given a signal by that. So that theory for damage to the national security also doesn't work. There was a pause temporarily so that there could be some assessment to address concerns the president had raised. The money was released by the end of the fiscal year. There was no damage to the national security, either in terms of material not being available to the Ukrainians or in terms of any signals sent to any foreign power. The money got out the door roughly the same time as in prior years, a little bit more left over at the end that had to be fixed, but there's some left over at the end every year that has to be fixed with a rider on the next appropriations bill or continuing resolution. So no damage whatsoever to the national security of the United States. Thank you.
Thank you, counsel. Senator from Hawaii.
Aloha. I send a question to the desk for the House managers.
Thank you. The question from Senator Hirono for the House managers reads as follows. In contrast to arguments by the President's counsel, acting White House Chief of Staff Mick Mulvaney stated that President Trump held up aid to Ukraine to get his politically motivated investigations. He claimed, quote, "We do that all the time with foreign policy," end quote, get over it, end quote. What was different about President Trump's withholding of aid to Ukraine from prior aid freezes? Are you aware of any other presidents who have withheld foreign aid as a bribe to extract personal benefits?
Thank you, Senator. I'll respond to the question, but let me begin with something in the category of you can't make this stuff up. Today, while we've been debating whether a president can be impeached for essentially bogus claims of privilege for attempting to use the courts to cover up misconduct, the Justice Department, in resisting House subpoenas, is in court today and was asked, well, if the Congress can't come to the court to enforce its subpoenas, because as we know, they're in here arguing Congress must go to court to enforce its subpoenas, but they're in the court saying, Congress, thou shalt not do that. So the judge says, if the Congress can't enforce its subpoenas in court, then what remedy is there? And the Justice Department lawyer's response is impeachment. Impeachment. You can't make this up. I mean, what more evidence do we need of the bad faith of this effort to cover up? I said the other day they're in this court making this argument, they're down the street making the other argument. I didn't think they'd make it on the same day. But that's exactly what's going on. Now, in response to the question about how does this aid different, this hold different from other holds, it's certainly appropriate to ask that question. The laws Congress passed authorizing this appropriation did not allow for the hold by this president, and as the GAO, the Government Accountability Office, found, it violated the law to hold the aid the way it did. Once the Department of Defense, in consultation with the Department of State, certified that Ukraine had met the anti-corruption benchmarks required under the law, there was nothing that would allow for a hold. The money had to flow. And that was intentional. Military assistance to Ukraine is critical to our national security. It has overwhelming bipartisan support. And recall that in the spring of 2019, the Defense Department certified Ukraine had met all of the anti-corruption benchmarks. The Department of State sent the Senate a letter saying that the benchmarks had been met. It issued a press release saying that the
Welcome back to Rudy Giuliani's.
It began to spend the funds to help Ukraine. But then the president stepped in. Without legal authority, he secretly placed a hold on the aid. Now, the President's counsel in their presentation gives specific examples of past holds as if we cannot distinguish one for a corrupt reason and one that is for a policy reason. In many of their examples, the law explicitly provided the executive branch the authority to pause, reevaluate, or cancel foreign aid programs as the situation in a recipient country evolved. For example, with regard to foreign assistance to El Salvador, Honduras, or Guatemala, the law explicitly allows the Secretary of State to, quote, suspend in whole or in part that assistance if at any time the Secretary deems that, quote, sufficient progress has not been made by a central government on a host of priorities from respecting human rights to upholding the law. Those are the priorities that you, the Senate, agreed to, and the President was required to implement them. Similarly, aid to Afghanistan is subject to periodic reevaluations by law, and the law explicitly directs the Secretary of State should, quote, suspend assistance for the government of Afghanistan should it be assessed that the Afghan government is, quote, failing to make measurable progress in meeting certain anti-corruption, human rights, and counterterrorism benchmarks. The overthrow of the democratically elected government in Egypt, we've had that brought up as another example. Members of this body, including Senators McCain, Leahy, and Graham, pressed the Obama administration to suspend military aid. It wasn't hidden from the Senate. It was urged on the administration by the Senate. Senators pressed for that aid to be withheld because the law was clear in instances of a military coup, aid must be suspended. Senators McCain and Graham wrote an op-ed in the Washington Post, not all coups are created equal, but a coup is still a coup. Morsi, that's the deposed leader of Egypt, quote, was elected by a majority of voters, and U.S. law requires the suspension of foreign assistance. I could go on with examples. No one has suggested you can't condition aid. But I would hope that we would all agree that you can't condition aid for a corrupt purpose, to try to get a foreign power to cheat in your election. Now, counsel says that if you decide the prosecution has proved that he engaged in this corrupt scheme, if you decide as impartial jurors that the Constitution requires his removal from office, that the public will not accept your judgment. I have more confidence in American people.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Arkansas.
I send a question to the desk on behalf of myself, Senator Cotton, Ernst, Young, Hawley, Risch, Fisher, and Hoeven.
Thank you. Senator Bozeman and the other senators pose a question to both sides. In the House manager's opening statement, they argue that it is necessary to pursue impeachment because, quote, the president's misconduct cannot be decided at the ballot box, for we cannot be assured that the vote will be fairly won, end quote. How would acquitting the president prevent voters from making an informed decision in the 2020 presidential election? The President's counsel goes first.
Thank you, Mr. Chief Justice, members of the Senate. That's exactly who should decide who should be president, the voters. All power comes from the people in this country. That's why you're here, that's why people are elected in the House, and that's why the president is elected. It's exactly who should decide the question, particularly in a case like this, where it's purely partisan. Here's the other thing, when we're talking about impeachment as a political weapon. They didn't tell you what they told the court over the holidays when they were waiting to deliver the impeachment articles. They went and told the court they're actually still impeaching over there in the House. Did you know that? They're actually still impeaching. They're coming here and they're telling you, please do the work that we didn't do, where we had 2 days in the House Judiciary Committee. We had the rush delivery for Christmas, and then we waited and waited and waited. But now we want you to call witnesses that we never called, that we didn't subpoena. They want to turn you into an investigative body. In the meantime, they're saying, by the way, we're still doing it over there. We're still impeaching. And they want to slow down now. They don't want to speed up. They want to slow it down and take up the election year and continue this political charade. It's also wrong. It's also wrong. Let's leave it to the people of the United States. Let's trust them. They're asking you not to trust them. Maybe they don't trust them. Maybe they won't like the result. We should trust them. That's who should decide who the president of this country should be. It'll be a few months from now. And they should decide. Thank you.
Thank you, counsel.
Chief Justice, Senator, I appreciate the question. President Trump must be removed from office because of his ongoing abuse of power, threatens the integrity of the next election. As we saw from the video montage, the president has made no bones about the fact that he is willing to seek foreign intervention to help him cheat in the next election. Now, counsel for the president says the next election is the remedy. It's not the remedy when the president is trying to seek to cheat in that very election. This is why the founders did not put a requirement that a president can only be impeached in their first term. Indeed, at that time, of course, there weren't term limits on the presidency. if it were the intent of the framers to say that a president can't be impeached in an election year, they would have said so. Now, they didn't for a reason, because they were concerned about a president who might try to cheat in that very election. Now, counsel, as I was getting to a moment ago, made the argument, if you make the decision as impartial jurors that the president has violated the Constitution, he has abused his power, he should be convicted or removed from office, that the country will not accept it. I have more confidence in the American people than that. But I will assure you of this. If you make the decision that a fair trial can be conducted without hearing from witnesses, the American people will not accept that judgment. Because the American people understand what goes into a fair trial. And they understand that a fair trial requires both sides to have the opportunity to present their case. We would like to present our case. We'd like to call our witnesses. We'd like to rely on more than our argumentation. There are a few things about this trial that Americans agree on, but one thing they are squarely in agreement on. Well, two. They believe a trial should have witness testimony, and they want to hear from John Bolton. That is the overwhelming consensus of the American people, and it's consistent with common sense. Let's give the country a trial they can be proud of. Let's show that at least the process worked and that we followed the founders' intent that a trial have witnesses. I don't think anyone can quarrel with the fact, when you look at the history of this body and every
Thank you, Mr.
single
Manager.
impeachment.
Mr. Chief Justice,
The senator from Virginia.
I send a question to the desk for the House managers.
Thank you. The question from Senator Kaine to the House managers. If the Senate acquits the President on Article 2, after he violated both the Impoundment Control Act and the Whistleblower Act to hide the Ukraine scheme from Congress, what is to stop President Trump from complete refusal to cooperate with Congress on any matter?
In short, the consequence is there is no constraint on this president or any other. This gets to a point you've heard counsel for the president repeat over and over. Can you be impeached for asserting privileges? And I would add, no matter how bogus or in bad faith those assertions may be. No matter whether they are in court today arguing the opposite of what they are arguing before you today. And the answer is yes, the president can be impeached for using the assertion of baseless claims to cover up his misconduct. The House did not impeach the president over a single assertion of privilege. We impeached him for a far more fundamental reason, because he issued an order categorically directing the executive branch to defy every single part of every single subpoena served by the House. A president who issues orders like this is a president who can place himself above the law and a system of checks and balances. He can do whatever he wants and get away with it by using his powers to orchestrate a massive cover-up. The president's lawyers haven't disputed that point. They can't. It's obvious that a president that ignores and can ignore all oversight is a threat to the American people. Instead, they've argued assertion of a grab bag of legal privileges warranting this categorical defiance. These arguments are unprecedented and wrong. The first thing to note is the president's arguments conveniently ignore the October 8th letter sent at the president's behest declaring that the president will not, quote, participate, unquote, in the impeachment investigation. I won't participate. This blanket defiance preceded all of the other letters and creative OLC opinions the president relied upon. It made clear that the rationale for blanket defiance was the president's belief that he can declare his own innocence and make it illegitimate to investigate him. This was not about privileges or legal arguments. Those came later as his lawyers rushed to justify that Congress has no power whatsoever to enforce subpoenas against anyone. Let's be clear. They may claim that their October 8 letter where they said they will not participate was somehow an offer to accommodate. But what the real condition was that the House simply drop the impeachment investigation or place the president in charge of its direction. That wasn't a real offer. That was a poison pill. Now, what about the remaining arguments? The first point is that none of them justify his order to defy all the subpoenas. He never asserted executive privilege over any documents. And his remaining arguments that absolute immunity or agency counsel not being allowed to attend depositions have nothing to do with documents. Nothing. So none of his legal arguments even applies to his direction that every single office and agency defy every single subpoena for documents. And what about the total obstruction on witnesses? Here, too, he never invoked executive privilege. Absolute immunity obviously couldn't apply to many of the lower-level officials we subpoenaed. The only remaining legal ground for defiance was the argument it's unconstitutional for Congress to prevent agency counsel from going to depositions. The fallback of fallbacks. Except this rule was originally passed by a Republican Congress and has been used repeatedly by both Republican and Democratic-led majorities and committees. It can't possibly justify obstruction of witness subpoenas. It's nothing more than a phony cover for an obstruction that President Trump decided upon at the outset. His arguments are thus incorrect on their own terms and fail to explain this categorical order. One final irony, even before the argument in court today. At a recent oral argument in the D.C. Circuit, they made the same claim they made today. Let's pull up slide 56. In litigation, again, to enforce subpoenas, the judge said they can make it a grounds for impeachment for obstruction of Congress. And the president's own lawyers said impeachment is certainly one of the tools that Congress has. We agree. It is one of the tools that you have. For when a president would use a categorical obstruction of investigation in his own wrongdoing, it is a tool that should be applied here. There cannot be a better case for impeachment on obstructing a co-equal branch of Congress than the one before you, where the obstruction is so complete and so categorical.
Thank you, Mr. Manager. The senator from Florida.
I sent a question to the desk on behalf of myself and Senator Braun, and it's to the President's counsel.
Thank you. Question from Senator Scott and Braun for counsel for the President. If Speaker Pelosi, Chairman Schiff, Chairman Nadler, and House Democrats were so confident in the gravity of the President's conduct and the overwhelming evidence of an impeachable offense that prompted the inquiry, why were the House Republicans denied the procedural accommodations and substantive rights afforded to the minority party in the Clinton impeachment? Additionally, why were the President's counsel and agency attorneys denied access to cross-examine witnesses during committee testimony and present the testimony of witnesses in defense of the issues under review?
Thank you, Mr. Chief Justice, members of the Senate. I don't know why they would do that. I don't know. They violated every past precedent. They violated all forms of due process. Now, they say that's a process argument, and it is, but it's more than that. It's more than that. If you feel confident in your facts, then why do you design a process that completely shuts out the president? Why do you cook up the facts in a basement skiff instead of in the light of day. Why do you do that? Why don't you allow the minority to call witnesses as they've had to do, have had the right to do in all past impeachments? And then they come here and say, by the way, we were fully in charge, so completely in charge that we locked out the President's counsel, denied all rights, denied the minority any witnesses at all. But when we come here, they still don't get witnesses. They want you not only to do their job, but to make the same mistake, the same violation of due process that they did. They said, well, let's just pick the witnesses that we want. The other ones are irrelevant, not relevant. In listening to Mr. Schiff over these months, I've come to a determination about what he means by irrelevant. He means bad for them, okay? He means witnesses that the President wants to call. So I don't know why they did that. I'll say something else. I'll say something else. I have respect for you and I have respect for the House. And when I first got this job, one of the first things I did is I went to visit Mr. Schiff, Chairman Schiff. I went to visit Chairman Nadler. I went to visit Chairman Cummings at that time. And I said, we're here to work with you, to cooperate where we can, but in the institutional interest, obviously, we'll participate in oversight. But if we have constitutional points to make, we'll make them, and we'll make them directly. And the administration has participated in oversight. Many, many witnesses have testified in oversight hearings. Large number of documents have been produced in oversight hearings. And in fact, in the letter that I sent on October 8th, I made the same offer. I said, look, this is not really a valid impeachment proceeding for all of the reasons that we've stated. But if the committees wish to return to the regular order of oversight requests, we stand ready to engage in that process. But that never happened. So I respect Congress. The administration respects Congress, but we respect the Constitution. We respect the Constitution, too. And we have an obligation to the executive branch and to the future presidents to vindicate the Constitution and vindicate those rights. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Oregon.
Mr. Chief Justice, I send a question to the desk for the House floor managers.
Thank you. The question from Senator Wyden for the House managers. The Intelligence Committee community is prohibited from requesting that a foreign entity target an American citizen when the intelligence community is itself prohibited from doing so. In 2017, Director Mike Pompeo's confirmation hearing to be the director of the Central Intelligence Agency, he testified that, quote, "It is not lawful to outsource that which we cannot do," end quote. So when President Trump asked a foreign country to investigate an American when the U.S. government had not established a legal predicate to do so, how is that not an abuse of power?
It is absolutely an abuse of power. And what's more, if you believe that a president can essentially engage in any corrupt activity as long as he believes that it will assist his reelection campaign, and that campaign is in the public interest, then what's to stop a president from tasking his intelligence agencies to do political investigations? What's to stop him from tasking the Justice Department if he can come up with some credible or incredible claim that his opponent deserves to be investigated? Their argument would lead you to the conclusion that he has every right to do that, to use the intelligence agencies or the Justice Department to investigate a rival, and when they become a rival, it's even more justified. But you're absolutely right. If Secretary Pompeo is correct and you can't use your own intelligence agencies, you sure shouldn't be able to use the Russian ones or the Ukrainian ones. And here, we have the president on that phone call pushing out this Russian propaganda, this Russian intelligence service propaganda, CrowdStrike, the server, as if there was just one server and it was whisked away to Ukraine. The Ukrainians hacked the server, not the Russians. A made-for-you-in-the-Kremlin conspiracy theory that undermines our own intelligence agencies but suits the political interests of the president, and his legal agent, Rudy Giuliani, is out there peddling this fiction. The president himself is out there promoting this fiction, standing side by side with Vladimir Putin. But you're absolutely right. It would be a monumental abuse of power, and it is a monumental abuse of power. And if you don't think abuse of power is impeachable, well, don't take my word for it. Don't take earlier Professor Dershowitz's word for it, or Jonathan Turley's word for it. Let's look to our Attorney General. This is what he said. Under the framers' plan, the determination whether the president is making decisions based on improper motives, something that Professor Dershowitz says we're not allowed to consider, based on improper motives, or whether he is faithfully discharging his responsibilities, is left to the people through the election process and the Congress through the impeachment process. The fact that the president is answerable for any abuses of discretion and is ultimately subject to the judgment of Congress through the impeachment process means that the president is not the judge in his own cause. Their own attorney general doesn't agree with their theory of the case. But again, we don't have to rely on Bill Barr's opinion or Alan Dershowitz's opinion or my opinion or the consensus of constitutional scholars everywhere. We can rely on our common sense, because the conclusion that a president can abuse his power by corruptly entering into a quid pro quo to get a foreign intelligence service or a foreign government, a foreign leader to do their political dirty work and help them cheat in the election, our common sense tells us that cannot be compatible with the office of the presidency. And if we say it is, if we say it's beyond the reach of the impeachment power, or we engage in this sophistry and we say, because you put it under the rubric of abuse of power, even though that was the framers' core offense, and you didn't put it under some other rubric, well, we won't even consider it. If we're going to engage in that kind of legal sophistry, it leaves the country completely unprotected from a president who would abuse his power in this way. That cannot be what the framers had in mind. The Constitution is not a suicide pact. It does not require us to surrender our common sense. Our common sense, as well as our morality, tells us what the president did was wrong. When a president sacrifices the national security interests of the country, it's not only wrong, but it's dangerous. When a president says, as we saw just a moment ago, over and over again, he will continue to do it if left in office, it is dangerous. The framers provided a remedy, and we urge you to use it.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Indiana.
I ask to send a question to the desk on my behalf and Senator Barrasso for the President's Counsel.
Thank you. Thank you. The question from Senator Braun and Barrasso for counsel for the President. The House managers have said the country must be saved from this president, and he does not have the best interests of the American people and their families in mind. Do you wish to respond to that claim?
Mr. Chief Justice, members of the Senate, while the House managers are coming before you and accusing the President of doing things, in their words, solely for personal and political gain, and claiming that he is not doing things in the best interest of the American people, the American people are telling you just the opposite. The President's approval rating, while we are sitting here in the middle of these impeachment proceedings, have hit an all-time high. A recent poll shows that the American people are the happiest they've been with the direction of the country in 15 years. Whether it's the economy, security, military preparedness, safer streets, or safer neighborhoods, they're all way up. We, the American people, are happier. And yet, the House managers tell you that the president needs to be removed because he's an immediate threat to our country. Listen to the words that they just said. We the American people, cannot decide who should be our president because, as they tell us, and these are their words, quote, we cannot be assured that the vote will be fairly won. Do you really, really believe that? Do you really think so little of the American people? We don't. We trust the American people to decide who should be our president. Candidly, it's crazy to think otherwise. So what's really going on? What's really going on is that he's a threat to them, and he's an immediate legitimate threat to them, and he's an immediate legitimate threat to their candidates because the election is only 8 months away. Let's talk about some of the things the president has done. We've replaced NAFTA with the historic MCA. We've killed the terrorists al-Baghdadi and Soleimani. We secured $738 billion to rebuild the military. There are more than 7 million jobs created since the election. Illegal border crossings are down 78% since May, and 100 miles of the wall have been built. The unemployment rate is the lowest in 50 years. More Americans, nearly 160 million, are employed than ever before. The African American unemployment, the Hispanic American unemployment, the Asian American unemployment has the lowest rate ever recorded. Women's unemployment recently hit the lowest rate in more than 65 years. Every U.S. metropolitan area saw per capita growth in 2018. Real wages have gone up by 8% for the low-income workers. Real median household income is now the highest level ever recorded. 40 million fewer people live in households receiving government assistance. We signed the biggest package of tax cuts and reforms in history. Since then, over $1 trillion has poured back into the U.S. 650,000 single mothers have been lifted out of poverty. We secured the largest ever increase for child care funding, helping more than 800,000 low-income families access high-quality, affordable care. We passed, as Manager Jeffries will recall, bipartisan criminal justice reform. Prescription drugs have been seen the lowest price decrease, the largest price decrease in over half a century. Drug overdose deaths fell nationwide in 2018 for the first time in nearly 30 years. A Gallup poll from just 3 days ago says that President Trump's upbeat view of the nation's economy, military strength, economic opportunity, and overall quality of life will likely resonate with Americans when he delivers the State of the Union address to Congress next week. If all that is solely, in their words, for his personal and political gain, and not in the best interest of the American people, then I say, God bless him. Keep doing it. Keep doing it. Keep doing it. Maybe if the House managers stop opposing him and harassing everyone associated with him with the constant letters and the constant investigations, maybe we can even get more done. Let's try something different now. Join us. Join us. One nation, one people. Enough is enough. Stop all of this. Thank you.
Mr. Chief Justice.
The senator from Colorado.
Thank you. I send a question to the desk for myself and Senator Schatz and Senator Menendez.
Thank you. The question from Senators Bennett, Menendez, and Schatz is to the House managers. If the Senate accepts the President's blanket assertion of privilege in the House impeachment inquiry, what are the consequences to the American people? How will the Senate ensure that the current President or a future President will remain transparent and accountable? How will this affect the separation of powers? And in this context, could you address the President's counsel's claim that the President's advisors are entitled to the same protections as a whistleblower?
Senate, privileges are limited. We have voted to impeach the President for, among other things, Article 2 of the impeachment is total defiance of House subpoenas. And the President announced it in advance, I will defy all the subpoenas. What does this mean? It means there's no information to Congress. It means a claim of monarchical dictatorial power. If Congress has no information, it cannot act. If the President can defy, now, he can dispute certain specific claims, you can claim privilege, etc., but to defy categorically all subpoenas, to announce in advance you're going to do that, and to do it, is to say that Congress has no power at all, only the executive has power. That's why Article 2 is impeaching him for abuse of Congress. That's why, for much lesser degree of offense, Richard Nixon was impeached for abuse of Congress, for the same defiance of any attempt by the Congress to investigate. But this is, and what are the consequences? The consequences, if this is to be, if he's to get away with it, is that any subpoena you vote in the future, any information you want in the future from any future president may be denied you with no excuses, announce in advance, I'll defy all the subpoenas. It eviscerates Congress and establishes the department, the executive department, as a total dictatorship. That's the consequences. Now, I want to also talk about, and the motives. The motives are clearly dictatorial. But I want to also take a point, since I have the floor, to answer a question, to comment on a question that Senator Collins and Senator Murkowski asked yesterday. And they asked about the question of mixed motives. What if, how do you define, how do you deal with a deed, with a president who may have a corrupt motive and a fine motive? And how do you deal with it? And Professor Dershowitz said, well, you have to look at the, you have to mix, you have to weigh the balances. Nonsense. Nonsense. We never, in American law, look at decent motives if you can prove a corrupt motive. If I am offered a bribe, and I accept the bribe for corrupt motive, I will not be heard in defense to say, oh, I would have voted for the bill anyway, it was a good bill. You don't inquire into other motives. Maybe you had good motives. But once the corrupt motive and the corrupt act was established, there is no comparison. All of this is just nonsense to point away from the fact that the president has been proven beyond a shadow of a doubt, and the defenders don't even bother really to defend. They just come out with distractions. He's been proven beyond a reasonable to have abused his power by violating the law to withhold military aid from a foreign country, to extort that country into helping his re-election campaign by slandering his opponent. Corrupt? No question. Violation of the law? No question. Factually? No question. They don't even make a real attempt to deny it. Everything is a distraction, and the one chief distraction is once you prove a corrupt act, that's it. You never measure the degree of maybe had decent motives too. So Professor Dershowitz, in talking about that, in talking about the absolute power of the presidency, was just absent from American law or any kind of Western law.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Georgia.
I send a question to the desk for the President's counsel on behalf of myself, Senator Ernst, and Senator Barrasso.
Thank you. The question from Senator Perdue, Ernst, and Barrasso for Counsel for the President is as follows. Please summarize the House of Representatives' three-stage investigation and how the President was denied due process in each stage. Combined with Manager Schiff's repeated leaks during the House's investigation, do these due process violations make this impeachment the fruit of the poisonous tree?
Mr. Chief Justice, Senators, thank you for that question. And the short answer, as I think I've indicated a couple of the times that I've been up here, is yes, this entire proceeding here is now the fruit of the poisonous tree. It is the fruit of a proceeding that was fatally deficient in due process from the start to the beginning. And as a result of that, it produced a record that is totally unreliable, can't be relied on here for any conclusion other than acquitting the President. And let me detail the three phases. First, the first error was that the House began the proceeding in a totally unconstitutional, unlawful, and illegitimate manner. It started an impeachment inquiry without any vote of the House to authorize that inquiry. And I want to spend a second on this because the House managers have spent a lot of time today trying to go back and argue about why their proceeding was all right. But they're not actually engaging the real issues. In order for the House to exercise the power of impeachment, there has to be a delegation of that authority to a committee. That's just a fundamental principle that the Constitution gives power to the House itself, not to individual members of the House, not to the Speaker. Just as here in the Senate, you wouldn't think that the majority leader could say, if an impeachment arrived, the majority leader could say, guess what, we're not going to do a trial with the whole Senate. I, the majority leader, am going to just decide that I'm going to have one committee hear the evidence, provide a summary, and then you all can vote. The majority leader doesn't have the authority on his own to do that. The Speaker doesn't have the authority in the House to give the power of impeachment to any committee to start pursuing an inquiry. And this is the key. There is no rule giving any committee in the House the authority to use the power of impeachment. Rule 10 speaks of legislative authority, not the power of impeachment. And all the subpoenas that were issued came with letters saying on them, pursuant to the House's impeachment inquiry. They purported to be using a power that hadn't actually been delegated to the committee. That's the first flaw. Illegitimate, unlawful proceeding from the start. Then there are the due process flaws. 3 stages of hearings. 1, secret hearings in the basement bunker. President's locked out. No opportunity to cross-examine witnesses, to see the evidence, to present evidence. And then they go from that to the public hearings, what's really just a public show trial, because the President is still cut out, totally unprecedented in any presidential impeachment, that there would be that second phase of public hearings where the President is still cut out, can't present evidence. The minority members don't have equal subpoena authority. The third phase in front of the House Judiciary Committee, they purport to have offered rights, but I've explained that. It was illusory because they had already decided before the President was supposed to respond with what rights he would like to exercise. The Speaker had announced the result. There were going to be articles of impeachment. The Judiciary Committee had decided they weren't going to hear from any fact witnesses. They had no plans for hearings. It was all a foregone conclusion because they had to get it done by Christmas. And the third error, that Chairman Schiff was in charge of all the fact-finding, and he had an interest, because of the interactions of his office with the whistleblower that we still don't know about, to shut down questioning about the motive, the bias, the reasons that the whistleblower, how this all came about. All 3 of those errors infected this process from the very beginning. They resulted in a one-sided, slanted fact-finding that was rushed by a person controlling the fact-finding who had a motive to limit what facts would be allowed to get into the proceedings. And it produced a record that cannot possibly be relied on here. We've said many times, the Supreme Court has made clear that cross-examination is the greatest legal engine ever invented for the discovery of truth, and they didn't permit the president the opportunity to cross-examine anyone. And that's an indication that the goal was not a search for the truth. It was a partisan charade intended to justify a preordained result and to get it done by Christmas. And it's not a record that can be relied on here. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Illinois.
I send a question to the desk for the House managers.
Thank you. The question from Senator Duckworth for the House managers. If the hold on aid to Ukraine was meant to be kept secret until the President could gather internal U.S. government information on Ukraine corruption and European cost-sharing, then is there any documentary evidence of this? For example, is there any evidence that the President was briefed on those issues by the NSC, DOD, or State Department during the period of the hold in the summer of 2019, or any evidence that he requested specific information on anti-corruption reform measures in Ukraine? Prior to releasing the aid on September 11, 2019, did the President order any changes to administration policy to address corruption in Ukraine or burden sharing with our European allies?
Chief Justice, thank you, Senator, for that question. Let's just take a moment and address what the process should have looked like. Because as we've already established and as President's Counsel has conceded and we've conceded, is this does happen. Right? There is a legitimate policy process for review and for determination on hold, because there is indeed legitimate policy reasons to hold aid. And we've never said that corruption is not one of those, or burden sharing wouldn't be one of those. What we're saying is there's no evidence that in what we are talking about today that the President was concerned or engaged that process. So what would normally happen is Congress would come together, as we did. We passed appropriations bills and we made a determination that funding was appropriate for the aid, which 87 members of the Senate did this past year. The President would then rely on the advice of government experts from the National Security Council, the Department of Defense, the State Department, and the Office of Management and Budget regarding that aid. That's the interagency process that we've talked so much about, the interagency process that we went through earlier last year. And at the conclusion of that interagency process, it was determined that it had met all of the conditions for the aid, and all the agencies determined that it should go forward. The President would then seek permission from Congress that he intended to, would normally, if there was a reason, the President would go back and seek permission from Congress to hold the aid. So let me repeat that. If there were a reason to hold it, the President, and President Trump has done this in the past under legitimate processes, as has President Obama and prior presidents, would go back to Congress under pre-described processes and make sure that they're not violating the Empowerment Control Act and seek permission to hold it. That did not happen. Congress would then weigh in on the request by either approving or denying the President's request. And then unless Congress specifically approves the President's request, the aid must be made available. Of course, none of that happened. In this instance, a hold was put in place. We don't know exactly when, because the President and his agencies have prevented us, and his counsel have prevented us from getting that information, but a hold was put in place. No reason was given. And in fact, the only one within the United States government who apparently knows why that hold was put into place is President's counsel, who tried to tell us last night why he thinks the hold was put into place, but nobody else knows. So yes, the answer is, if there was a legitimate policy process put in place, there will be a lot of information about burden sharing about corruption, about any of the other concerns to which we have no evidence. And if burden sharing, to the last point of the question, was a concern, then the person who should have been asked to discuss those concerns with the EU and our European partners would have been Ambassador Sondland, because he is the United States ambassador to the European Union. And not once did President Trump go to Ambassador Sondland and say, discuss these issues with the EU and the Europeans, saying they need to provide more money. Not once did that happen, and it didn't happen because it wasn't the real concern. All of the evidence shows the president withheld taxpayer money, foreign aid to our partner at war, to coerce them to start a political investigation to benefit his 2020 election campaign. That is what the evidence shows, and that's why we are still here. And there is one person that can provide additional information on that, and that is Ambassador Bolton. And yes, it is still a good time to subpoena Ambassador Bolton.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Maine.
I send a question to the desk on behalf of myself and Senators Crapo, Blunt, and Rubio.
Thank you. The question from Senator Collins and the other senators for both parties: are there legitimate circumstances under which a president could request a foreign country to investigate a U.S. citizen, including a political rival, who is not under investigation by the U.S. government? If so, what are they and how do they apply to the present case? The House goes first.
Mr. Chief Justice, Senator, it would be hard for me to contemplate circumstances where that would be appropriate, where it would be appropriate for the President of the United States to seek a political investigation of an opponent. One of the, I think, most important post-Watergate reforms was to divorce decisions about specific cases, specific prosecutions, from the White House to the Justice Department, to build a wall. One of the many norms that has broken down under this presidency is that wall has been obliterated, where the president has affirmatively and aggressively sought to investigate his rivals. I cannot conceive of circumstances where that is appropriate. It may be appropriate for the Justice Department, acting independently and in good faith, to initiate investigation. There's a process for doing that. We heard testimony about that. You can make requests under the Mutual Legal Assistance Treaty, the MLAT process, when a foreign country has evidence involving a criminal case involving a U.S. person. There is a legitimate way to do that. That didn't happen here. In fact, when Bill Barr's name was first revealed, when that transcript was brought to light, the Justice Department immediately said, we have nothing to do with this. We have nothing to do with this. Here, this particular domestic political errand was being done by the president's personal lawyer. I wanted to follow up also, while I can, Senator, on my colleague's comments in terms of mixed motives. If you conclude the president acted with mixed motives, some of them corrupt and forbidden, some of them legitimate, you should vote to convict. That principle is deeply rooted in our legal tradition. It is commonplace in civil and criminal law going back centuries. For example, in describing the standard for corrupt motive for obstruction, the Seventh Circuit rejected any requirement that a defendant's only or even main purpose was to obstruct the due administration of justice. Instead, the court explained, a defendant is guilty if his motives included any corrupt, forbidden goals. That case, United States v. Cueto, which I cited earlier, is not only relevant here, but that case was argued by Professor Dershowitz, and he lost. He made the argument he's made and the president's lawyers have made today. They lost that case, and for a good reason. It's contrary to the history of our legal traditions. If someone, and this is the founders were concerned, for example, that a president might be charged with bribing members. of the Electoral College.
Mr. Chief Justice, Senators, thank you for that question. I'd like to start by pointing out that the question sort of assumes that there is a request for an investigation in a foreign country of a United States person. I'd just like to bring it back, though, here to the transcript of the July 25th call, where President Trump didn't ask President Zelensky specifically for an investigation or an investigation into Vice President Biden or his son Hunter. I mean, there's a lot of loose talk in sort of shorthand reference to it that way, but what he refers to is the incident in which the prosecutor was fired. And the first thing that he says in that whole exchange is talking about the prosecutor being fired. And he says it sounds horrible to him. And the situation with Burisma. And so, and all that the president says is, so if you can look into it, it sounds horrible, it sounds like a bad situation. That's not calling for an investigation necessarily into Vice President Biden or his son, but the situation in which the prosecutor had been fired, which affected anti-corruption efforts in the Ukraine. And President Zelensky responded by saying, the issue of the investigation of the case is actually the issue of making sure to restore the honesty, so we will take care of that. And he's explaining that he understands that it's an issue that has to do with, was an investigation over there, that their prosecutor was handling, derailed in a way that affected their anti-corruption efforts, and it's something worth looking into. It's the president making clear that we're not saying that's off limits. It sounds bad to the U.S. as well. But let me get more specifically to the question, is there any situation where it might be legitimate to ask for an investigation overseas? Yes, if there was a conduct by a U.S. person overseas that potentially violated the law of that country, but didn't violate the law of this country, but there was a national interest in having some information about that and understanding what went on, then it would be perfectly legitimate to suggest this is something worth looking into. We have an interest in knowing about this, even if it's not something that would mean a criminal investigation here in the United States. And so that could arise in various circumstances where a person had done something overseas, but there was a national interest in understanding what they had done. Thank you.
The Democratic leader is recognized.
Mr. Chief Justice, I send the question to the desk for the President's Counsel and the House managers.
Thank you. The Democratic leader's question is this. Yesterday, I asked the President's Counsel about the President's claim of absolute immunity. Specifically, I asked the President's lawyers to name a single document or witness that the President turned over to the House impeachment inquiry in response to their request or subpoena. Mr. Philbin spoke for 5 minutes and talked about the various types of immunities and privileges the President could invoke, but did not answer my question. So I ask once again, can you name a single witness or document that the President turned over to the House impeachment inquiry? It is directed to both parties, and President's Counsel goes first.
Mr. Chief Justice, Minority Leader Schumer, thank you for that question. I apologize if I was not direct in getting to the nub of the question yesterday. I was intending to explain the rationales that the administration had provided for its actions and to explain, contrary to the question, that it was not simply absolute defiance and not simply a blanket assertion that we won't do anything. That's the way the House managers have tried to characterize it. But so let me be clear. There were document subpoenas issued prior to the adoption of House Resolution 660. The President explained, the administration explained in various letters, all of those were invalid, and there were no documents produced in response. There were no documents produced in response because all of those subpoenas were invalid. There was no attempt to reissue those subpoenas or to retroactively attempt to authorize them. There were then subpoenas for witnesses who were senior advisors to the president. The president advised the committees that had issued those that those senior advisors had absolute immunity, and they were not produced for testimony. Those 3 senior advisors were not produced. There were then subpoenas for witnesses to others who the House managers, the House Democrats insisted they would be required to testify without the benefit of agency counsel, and I've explained that principle. The Office of Legal Counsel advised that those subpoenas attempting to require executive branch officials to testify without the benefit of agency counsel were unconstitutional, and so those witnesses were not produced. Still, there were 17 witnesses who testified, not including the 18th witness, the ICIG, whose testimony is still secret. So there was quite a bit of testimony, and there have been subsequently some documents relevant to this produced under FOIA. And I raise that because it makes clear that if you follow the law and you follow the rules and you make a document request that's valid, documents get produced. If you don't follow the law, the administration resisted. That's why the documents weren't produced, because the subpoenas were invalid, and we made that very clear. Thank you.
Thank you, counsel.
Not a single document was turned over, not a single witness was produced, and the witnesses that did come came in defiance of the orders of the president. Now, counsel has obviously made all these claims that we think are completely spurious, but what they don't answer is, what was the motivation to fight all the subpoenas? They argue this interpretation which the courts have rejected, that have looked at it, that somehow these subpoenas were invalid. But why didn't they produce the documents? Why did they insist on this now discredited by the court's legal theory? Because they were covering up the president's misconduct. Now, I want to return briefly to finish the comments I was making earlier about the senator's question earlier on mixed motives. There's a good reason why mixed motives are no defense. Otherwise, officials who committed misconduct could always claim that even if they did it, that even if it was corrupt, they must be acquitted because they were able to invent some phony motivation and insist it played some minor role in their scheme. Imagine how that principle would apply to a president charged with bribing members of the Electoral College. Multiple framers cited this specific threat while discussing impeachment at the Constitutional Convention. Could a president